Don't have a quorum. Okay. Representative Keel. Ladies and gentlemen, we're going to go ahead and get started with the judiciary. We appreciate change of rooms. We're normally we're in room 200. I'm the vice chairman, Tim Wadsworth. Judge Hill is out at this point, but we'll come in a few minutes. And I wanted to give you a little background about the order. We're going to take HB 293, Representative Keel's bill first, and then we're going to then go into the public hearings after that. Call, you want to call quorum?
Hill, Wadsworth.
Here.
Coleman. Here. Allen, Ball, Chestnut. Here. Drake. Here. England, Farley. Here. Faulkner, Holmes. Here. McClammy, Pettis, Robbins. Here. Simpson. We have a quorum.
Okay. We have HB 293, Representative Keel. Does anybody have any questions about the bill? Any amendments to the bill? Is there a motion to give the bill a favorable report? Is there a second? All in favor to give the bill a favorable report, say aye. All opposed? The bill gets a favorable report. Thank you, Representative Keel. The first public hearing we're going to have is HB 314, Robbins. And would you please give us some information about the bill? Please.
Can you hear me? Good. Well, I'm here to present HB 314. It's a child custody bill, and what we're hoping to do with 314 is, the main point of 314 is that we want to make sure that there's a fair custody arrangement for mothers, fathers, and the child gets to have access with the parents. But what 314 does is that it makes sure that a judge is able to have that discretion and able to make those decisions based upon a set of factors that are set out in the bill. Because everyone here knows that all divorces, all custody cases are not equal, and we can't treat them equally. So a judge needs to be able to make that decision based upon the factors placed in front of him or her on what is in the best interest of the child. And the heart of 314 is the best interest of the child. And so that's the gist of the bill. And I don't know if we're going to be open for questions today, or you want to just hear from the witnesses, and then we'll answer questions next week.
We've got to go back in at 4, so what we're going to do today is we're going to hear from the proponents and the opponents of the bill, and then we will not be voting on the bill today. It'll come up next week. The first proponent is Dr. Tinsley Griffin Hill, and we're going to limit everything to 2 minutes because we've got 3 public hearings and probably about 15 to 20 people. So,
Thank you, Mr. Chairman and members of the committee. I'm actually speaking on behalf of Judge Philip Lisenby today. He wanted to provide a comparison for you between House Bill 365 and our bill, House Bill 314, speaking in favor of 314. So Judge Lisenby was here last week. He was unable to join us today, so he sent this statement. From Judge Philip Lisenby. I served as a juvenile and family court judge in Tuscaloosa County from 1996 until my retirement in 2020. As a juvenile and family court judge, I was responsible for cases involving the custody and welfare of children. During my career, I estimate that I handled approximately 20,000 cases. The overriding consideration involving children is, and should be, doing what is in the best interests of those children. The vast majority of the cases for which I was responsible were resolved by the parties involved. It is essential that we encourage parents to resolve custody matters in a manner that meets the needs and goals of the parents and consistent with the best interests of their children. The trial of a custody matter is, most often, an ugly and emotionally draining experience for the parties and the children. It is also very expensive for the litigants. We should encourage parents to resolve these matters without the necessity of a trial. Both of these bills, 314 and 365, provide a framework for parents to consider their needs, goals, and circumstances and create a custody arrangement for them. The primary difference between the two bills is the presumption in House Bill 365 that a court must essentially split custodial time equally between parents when entering an order for joint physical custody. Family court judges already have the necessary legal standard to decide these cases, to do what is in the best interests of the children. The judge is the only person who actually, during the course of a trial, sees and hears the parties and witnesses. The demeanor and presentation of the witnesses is such an integral part of the trial process that appellate courts are required to give great deference to the decisions made by judges. Simply stated, the imposition of any additional statutory standards, such as the 50-50 presumption stated in HB 365, erodes the ability of the trial judge to, after carefully considering the evidence and circumstances of each case, enter a judgment consistent with the consideration of the best interests of the children. A custody determination is one of the most important
Let me
decisions.
mention, the 2 minutes is up. However, if you have got a paper that you want to make a copy of to provide the rest of what you are presenting to the other members, if you will make a copy and give it to our clerk back here, and they'll provide the ballot.
Yes, absolutely. I have one here that I can pass around, and I'm happy to email it as well. Thank you so much.
Okay, thank you. We have an opponent, and it's Tim Smith. At the end of when everybody has spoken.
Good afternoon. I'm Tim Smith from Decatur. I'm a 23-year member of Alpha. I want to thank the.
Hang on just a second. Yes.
Thank you, Mr. Chair, for the recognition. I just have a quick question. Are we doing both of these public hearings? Are people talking about this interchangeably, or are there 2 different public hearings?
There's 2 separate public hearings. The first one's on HB 314, and then the second one's HB 365.
Thank you. I just wanted to make sure I understood the process for today.
And we've got 4 proponents and 2 opponents of HB 314, and we've got 4 proponents of HB 365 and 6 of HB 365 opponents. Didn't mean to interrupt, but go forward, please.
That's okay, sir. Thank you, Chair, and thank you for the committee for the opportunity to speak here on HB 314. I want to thank the ALI, the Alabama Law Institute, for the time and effort they put into the wordage of this bill, and to thank Representative Robbins for bringing this bill forward. That said, additional work needs to be done to this piece of legislation to protect children's access to their parents. Opportunities before this committee to review and shape a very important piece of legislation. Legislation that can protect the right of children to enjoy the love, protection, and care of, and access to both their fit parents. I'm going to digress a little bit from my printed statement and tell you two things. In 2003, Alfred was instrumental in getting the Alabama Parent-Child Relationship Protection Act passed, which assures neither parent can move without notifying the other parent. That was done in 2003. No problem with that piece of legislation. Also, the 23rd Circuit, Madison County, in their Pendente Light, has, when parents can agree, that it is 50-50 custody, 1 week with one parent, 1 week with the other parent, in the residence until the final order comes through. That can be found on the web just with a simple search. We're here today because present law does not have the language needed to protect the best interest of the child or spell that out. 314 does that, but it needs two things. It needs a rebuttable presumption that joint custody is in the best interest of the child, because we're dealing with fit parents. And it needs, anytime any other kind of custody is awarded by the court, findings of fact that sways the court in their decision needs to be written down where all the parties know exactly what was in the court's mind when they made that determination. These changes to HB 314 will help conserve the natural protective relationship children have with both their fit parents following separation or divorce.
Okay, that's time.
Attention.
If you've got additional in a written material that you'd like to provide to the members of the Judiciary panel, we'll be happy to accept that.
I do not have them printed because my printer laid down. I will email them to each member. Will that be okay?
That's fine.
And then in the header, I will have where it's in opposition to 314, how it's written.
Thank you, sir.
Thank you.
It might be best, sir, to email it to the clerk. Because some of our emails are different.
I will do that. Thank you.
I just wanted on the record that that was Representative Faulkner that requested that, Brandy, so don't get mad at us.
We have a proponent, Ann Durwood. Judge, okay. Sorry about that, Judge.
Hey, good afternoon. My name is Ann Durward. I am a service circuit court judge in Jefferson County, which is the 10th Judicial Circuit, and I serve in the Domestic Relations Division. I've been serving in the Domestic Relations Division since 2020 when I was appointed to the bench. Prior to that, though, I was a practicing attorney in family law for 25 years. I have represented men, I have represented women, and I have represented children. I have been handling cases under the current joint custody bill that ALI put forth back in 1994, which was written in response to appellate courts that saw a need for a statutory definition of what is joint custody. I am a proponent of HB 314 because it takes it to the next step. It clarifies a lot of issues that need to be clarified. It gives, as a judge, a statutory framework in which to work. It is a good, solid bill as it is drafted. It has been vetted by people who practice in this area, who deal with it on a day-to-day basis, and who have studied the science. 314 will take into account what is in the best interest of the children, which is, as a judge, we keep at the foremost of our mind every single day. Every single decision we make deals with the best interest of the children. And the key difference in the two, and I'll go into that when I have to stand up with HB 365, is 314 recognizes that judges need discretion. We need good discretion and a good framework in which to work, and that is what 314 gives the judges, and it gives the parties. It is a way for 90% of the cases to be resolved because of the parenting plans that are going to be presented and the presumption that both parties agree that they want joint custody, then joint custody will be given. And it gives us as judges an idea as what parents think is the best way for them both to have access to these minor children. And that is why I'm a proponent and here on behalf of the Circuit Judges Association in support of HB 314. Thank you.
Thank you, Judge, and I appreciate it.
Mr. Chair, I just have to add, if you don't mind, that is one of my judges from
Okay, very good.
Judiciary came to visit with us at the Judiciary Committee of the Alabama Legislature, and more judges coming down to visit us.
And good.
Now I have to add, that's one of my judges too. And one of my friends. Known her her whole life.
Well,
Don't hold that against me, though.
we appreciate you coming. Another opponent is Nicole Clark.
My name's Nicole Clark. I'm a practicing attorney here in Autauga County. I also practice in Elmore, Chilton, and Montgomery County. As it's written with 314, I think it's a great bill. It does kind of codify what we're currently practicing through case law. However, that rebuttable presumption is very key in what needs to be in there. That language needs to be included. It's cited over 54 times in our current code. It's cited over 9 times in Title 30, which is what deals with custody and divorces. It is actually also included in 33-131, which is your domestic violence provision under the custody code. It states there's a rebuttable presumption that a parent that has been found as a perpetrator of domestic violence cannot be a fit parent. One of the other things that I keep hearing about 314 is it gives the judges discretion. The judges have discretion under both bills, and I'll talk about that more when I'm talking on behalf of 365. But rebuttable presumption, that's so key. It's in our grandparents' rights provision as well. There's a rebuttal presumption in the grandparents' rights case. So it's not fair to give a higher standard to grandparents than you're going to give to the actual parents of the child. Rebuttable presumption means that there's a presumption there on the start, but you can rebut that very easily with facts or findings. So if both parents are not fit, if one's a drug addict or a perpetrator of domestic violence, that can be proven very easily with facts. But it's not fair to just go in and say, we're just going to put y'all on opposite or uneven playing field. We need to be on an even playing field to start with, and then let the facts tip the scales one way or the other. As in regards to the other big issue, the difference between the two bills is a finding of fact, a writing. How is it fair to tell a parent that they cannot have access to their kids or only see their child 2 or 3, 4 times a month and not tell them why? That they have a constitutional right to be a parent. Why are we limiting that without explaining why? That's not very hard to do. The list, both bills list out reasons to deviate from that rebuttable presumption. Both of them give the judges discretion. So honestly, a marriage between the two bills would be ideal, and that would be what we would need to work under.
We appreciate it, and your time is up. Thank you.
Thank you.
At this time, Honorable Judge Hill, Chairman of the Judiciary, has come in, so we're going to turn it over to Judge Hill to complete.
Goodness gracious. Sanders? What's your name, ma'am?
Mary Elizabeth Kurtner Smith.
Okay, Miss Dr.
I know, it's a long name. I worried that maybe this would take up my 2 minutes to say my name.
No, ma'am, my inability to pronounce your name is not going to be counted against you.
Thank you.
Thank you, ma'am. Please go ahead.
Thank you. I have a PhD in child development and family relationships and child psychology. I am retired from the University of Alabama, Department of Human Development and Family Studies. I taught and did research there for 29 years. I taught a graduate and an undergraduate course in children of divorce, which meant that I had to stay on top of the research. HB 314, or I'm here to speak in favor of HB 314, It will require each family to propose a parenting plan, which describes how each parent will fulfill their parenting responsibilities. Currently, only parents seeking joint custody have to do that. The parenting plans are important because they help parents avoid future conflict. I would direct you to a website that the Alabama the Alabama Law Institute has developed, in which we have developed model parenting plan court forms. We also have 111 developmentally appropriate time-sharing schedules. HB 314 states that if both parents agree on custody, then that arrangement will usually be ordered unless, of course, a parent is found to be violent or abusive or has serious mental health issues. HB 314 requires judges to consider joint physical custody in every case, simultaneously while considering the individual facts presented by the parents. An important note that I want to say is that oftentimes in social science research, joint physical custody is determined by having the child spend a minimum of 35% of their time with each parent. Therefore, in the social science research, joint physical custody has time splits that vary from 35 to 65, 40 to 60, and 50-50 time splits. All have been found to be beneficial to children, but not all time splits fit every family. Thank you. Thank you.
Mr. Chairman, members of the committee, I thank you for the opportunity to rise and speak in favor of House Bill 314. My name is Adrian Johnson. I serve as district judge in Lowndes County, Alabama, and have been there for the last 11 years. I also sit as a specially assigned circuit judge handling all the domestic relation cases in my county, as well as all the juvenile and child support cases. I'm also the past president of the Juvenile Judges Association and District Judges Association. I'm here in favor of 314 because it does a number of things that I think are positive under Alabama law. It streamlines the definitions under Alabama law to keep them in line with what we see in case law and what courts are commonly utilizing in their final decrees. It also adds an important provision in that it codifies the McClendon standard, which is the standard that we have to do on any modification of an initial custody award. It also adds a provision that allows parents to be able to file and come back before the court to address deviations from the parenting time without the necessity of coming in and paying a filing fee and filing a subsequent petition for contempt. So it streamlines the court proceedings. So there's several important factors that are in the bill that are positive. The primary distinction, and the reason I'm a proponent of 314, is that it maintains judicial discretion. Because the judge is the person that's hearing these cases. There's a reason we have the ore tennis standard under Alabama law, is that the judge has an opportunity to hear those witnesses, hear the testimony, consider that evidence, and make a determination based on the evidence that comes before the court. So when we have an opportunity to hear from the parties, the first consideration that we have to consider is the best interest of the child. Not what's best for the parents, but what's best for the child. We already have a presumption when both parties are filing requesting for joint custody that joint custody is in the interest of the child. These situations are primarily related to where you have parties that are coming in that are filing a contested divorce, and there is a distinction in what the parties are asking for. Either both are asking for primary physical custody, or one is asking for joint and one is asking for primary. And a deviation of that standard removes that from what's the best interest of the child and puts it in what the parents want. And so as a judge, I'm asking that you give serious consideration in favor of House Bill 314 to ensure that we maintain judicial discretion, to allow for the judges to ensure that the child's interest in first and foremost in the things that we do, so that we can give both parents an opportunity to ensure that they have the time needed to be a part of that child's life. And I thank you for your consideration.
Judge, thank you a lot. We appreciate you coming. Ladies and gentlemen, at this point in time, to the committee, not to the sponsor of the bill, but to any of the individuals that spoke, would any member of the committee like to ask a question of any one of the sponsors, or the speakers? Yes, sir, Mr. Faulkner.
Okay, there we go. It was the Alpha, I think, is that it right? Am I saying that right? Alpha, the ma'am, yes ma'am. Was it you who spoke? I did. Oh, could I ask you a question? Sorry, I forgot your name.
Clark.
Ms. Clark, thank you for coming back up. I wanted you said that the marriage between the two bills would be what you were seeking. So I was just wanting to clarify. You are not obviously you wanted changes to be made to 314 to vote for it, and I assume you're wanting changes to be made to 365 if that's the other bill. You're not really in favor of either one as they are.
I am absolutely in favor of 365. It is written well. If you put the two bills very close together, there are three main differences between the bills. The rebuttable presumption is one of them. The written finding of facts is one of them. And the other, 365 better defines joint custody versus the 314.
So is it your opinion then that 365 makes all the changes, it incorporates all the changes you wanted to 314?
Yes.
Because I thought you said it would be a marriage of the two bills.
If you put them beside each other, that's the only differences.
Okay.
So if you could amend it to include some or all of that language, I will be happy.
And the rebuttable presumption is your main thing that you wanted in
and
314?
The rebuttable presumption and the finding of facts. Both of those, I think, are very important. Like I said, if we're going to give the rebuttable presumption standard to grandparents, why are we not giving that to parents?
Okay, thank you, ma'am. Yes, ma'am, Ms. Coleman. Same lady.
Well, no, I don't have a question. It's a suggestion. You know, this is the chair. Of course, this is however you run your committee. But if the same people are going to be speaking against the next one and for however it's going, maybe we should reserve our questions until we've heard both public hearings. Just a suggestion.
And that suggestion's well taken. So thank you very much. We will do that. So let us move on to the next bill, which is 365. Have you had a chance to explain this bill?
No, I have not.
Please do so.
Now, he's got a substitute. Is he gonna talk to the sub?
I don't know what he's doing. I don't know.
Your microphone's on.
I heard that too.
I don't know what, I have read your bills. I'm ready to listen to you explain them.
Okay. Mr. Chairman and committee members, I'm honored to stand before you. This conversation started in 2008. The bill that's before you started in 2008. The legislators said our code is outdated and we need to update our family law codes to look at the best practices. And so from 2008 to 2011, we introduced a bill here in the House. In 2017, we introduced a bill upstairs in the same posture. We had this pretty much the exact same situation upstairs. And the bill before you is, we merged the bills together. So the bill before you today is a bipartisan legislation aimed to maximize a child time with both of their two fit parents when the parents divorce or separate. This bill consists of language from the Alabama Law Institute Family Law Committee. It includes data from the family law section of the Bar Association from 2012 that's emphasized the rebuttable presumption language. It's a result of two judges' surveys. Just want to quote one quote from from the judges' surveys regarding joint custody and the presumption. This was administered by the officer, administrative courts here in Alabama, directed from the Supreme Court. One of the survey questions was, how often do you order joint equal custody, physical custody? And the comment from the survey by the judge, I have never in 10 years awarded true custody or 50-50 custody in a case. I do not believe that such instability is ever in the child's best interest. Therefore, I do not do it on my own accord. Another response, I don't like having children go back and forth. I really think stability is in every child's best interest. Don't want the child to think mom or dad is competing. I would never order equal custody. Also, this bill before you, it's a result of consulting with judges, lawyers in the 67 counties in Alabama over the last 10 years. Also, before you should have a substitute bill. I did exactly what one of the speakers asked. I consolidated the bills. The substitute bill you have in front of you, the highlighted areas are the difference between the two bills. And I just wanted to, while we're here, this bill creates a rebuttable presumption that approximately equal is in the best interest of the child. Currently in the 67 counties in Alabama, the definition of best interest of the child and the presumption depend on what judge and what county you live in. In majority of the counties, the presumption is dad gets to see the child 48 to 56 hours twice a week. What my bill does, it creates a presumption that approximately equal. As one of the individuals testified earlier, there's over 40 studies throughout the country. Usually, this bill do not say 50-50. One of the speakers misquoted and stated that is incorrect. My bill do not state 50-50. It states approximately equal, because the research, the experts say when a child spends 35% to 50% time with both of their parents, kids have better outcomes. So my bill is not about judges. My bill is not about domestic violence. My bill is not about grandparents. My bill is about seeking best outcomes for our kids in Alabama. I have an obituary in front of me. The death of this young black man was in 2014, but I knew he was dead in 2007. You may say, why? Because the best interest of the child standard here in Alabama, there's just one out of thousands and thousands of kids that's shot, killed, murdered, commit suicide in Alabama because of current standards. I knew he was dead in 2007, 7 years before. You may say, why? Because the data tell us that. When we deprive kids of one of their parents or relegate a child to seeing one of their parents 48 to 56 hours twice a month, often kids commit suicide. They have behavior problems in our schools. In our major cities, we see gun violence. As I talk to our sheriffs and police chiefs, I ask them what is the common denominator they see in all of these major violent crimes in our communities. Kids having a limited time with one of their parents, and we call that the best interest of the child standard here in Alabama. So with that, Mr. Chairman, before you, committee members, if you don't have a substitute bill, let me know, I'll get you a copy. But next week I can share more, but that's just summarize the bill. Once again, it's a consolidated efforts between judges, lawyers, and social science data.
Yeah, thank you, sir.
Thank you.
Appreciate it very much. We've got several people to speak. I will ask this. If this is 365, if you're going to say basically the same thing, how about let's keep it as quickly as we are able to do so. Ms. Granderson? There you go. Thank you. Nope. I tell you what.
Thank you, Judge Hill.
I'm going to allow Mr. Drake to start calling names from now on.
Thank you, members of the committee. My name is Amanda Griesdorn. I'm a resident of Alabama, child of divorce, married, a stepmother, and a business professional. I've been working with the Alabama Family Rights Association for approximately 11 years to change the child custody laws in Alabama. Thank you for hearing me today. The success of children and their growth to adulthood is correlated to the time that children spend with each of their parents. When time is restricted, children are said to be at risk. We all know this, but what we didn't know is that risk factors add up, and 4 or more risk factors increase the chance of suicide by 1,200%, according to the Adverse Childhood Experience Study, ACE study is what it's called. Furthermore, the ACE study is only one of more than 40 social science studies conducted in the past 40 years that show the important correlation between time spent with mom and dad to a child's development, health, and success in life. Forward-thinking states, Ohio, and I hate to say this, Kentucky, I don't think of it as forward-thinking, but heavens to Murgatroyd, have led the way to use this data to protect children in their states by changing child custody laws, proving that changes decrease negative outcomes, reduce court dockets, and help children succeed. Parents are determined. The new proposed law that you have before you does a few really powerful things that are key to preventing suicide, conflict, drug addiction, teen pregnancy, and increasing high school graduation rates. Parents are determined to be fit at the outset so that if they are not, action can be taken to prevent abuse within the home.
Thank you, and I do appreciate you coming. Very, very much. Thank you so much. Dr. Hill, I did say that one right there.
Yes, you did, Judge Hill. Thank you all so much. I realized last time I didn't introduce myself. I'm Dr. Hill. I am the newest attorney for the ALI, so if you've seen me running around, that's where you know me from. And I am going to finish Judge Lisenby's statement, but before that, I wanted to turn your attention to page 5 of the substituted 365 bill. The definition for joint physical custody under this bill reads, a custody arrangement where physical custody is shared by the parents in a way that assures the child frequent and substantial contact with each parent. Frequent and substantial contact means that the child has equal or approximately equal time with both parents. So under 365, it is, under the text of the bill, a 50-50 split. And that was the concern for Judge Philip Lisenby, who was here last week. So I'd like to read the last paragraph of his statement. Simply stated, the imposition of any additional statutory standards, such as the exact 50-50 presumption contained in HB 365, erodes the ability of the trial judge to, after carefully considering the evidence and circumstances of each case, enter a judgment consistent with the paramount consideration of the best interests of the children. A custody determination is one of the most important decisions a judge can make, and it certainly has lifelong implications for the children. Please do not make it more difficult for a judge to do the right thing. On behalf of the judges who are charged with making these decisions and the children who have to live with these decisions, I am asking for your support for HB 314, the ALI bill. Thank you.
One of the things that we keep hearing is judge's discretion, judge's discretion. And if you'll turn to page 10 of the substitute bill, paragraph 18, numbered 18, states any other relevant factors. That statement alone gives the judge the discretion to deviate from the rebuttable presumption that joint custody is in the best interest of the child for any reason that they see fit. What 365 is also asking is that the judge just be required to state out why they're deviating from that. This 365 in no way takes away the judge's discretion to do their job. We know that they're charged with protecting our children as we are as parents. This bill provides a way for them to do that, but it also protects our parents' constitutional right to know why they don't have access to their children. That is so vital. Thank you.
Sir. Let's wait till everybody.
Just one purpose of clarification. I just wonder what page and line she preferred.
It was page 10, number 18. It's line 6 at the top of the page.
Thank you, ma'am. Appreciate it. Judge Durward.
Yes, hello. I'm back before you again on behalf of the Circuit Judges Association. And I just wanted to point out, I was emphasizing before the positives, and there are great positives in both of these bills. But what is concerning as a family law practitioner, as well as a judge who is in this area, is the presumption that has been put into this statute that they are proposing. That statute requires frequent and substantial contact that means a child has equal and approximately equal time with both parents. But even more troubling as a judge is the provision that says there shall be a rebuttable presumption that requires written findings of fact that can only be overcome by, in the way that that is worded, that is going to be a clear and convincing standard. That's what's cited in all those other statutes that they reference. And I do want to distinguish the difference between the grandparent visitation rights. That's a third party who is coming in against a parent. Am I talking too loud?
Can you explain to non-lawyers
Yes.
the standards, clear and convincing, and
Sure, I'll do my best.
No.
I may want to defer to the law professor back here, but no. So we have, as judges, different standards that we have to review evidence. And in this regard, in dealing with typical child custody cases, it's a best interest standard. They have put heightened burdens, and that would be everybody's on the same playing field. We're here. You hear the reasonable doubt. That's what you hear in criminal cases because you have life, liberty, and all those rights that are being affected. Clear and convincing is right below that. That is right below reasonable doubt that you have for somebody who's accused for murder, that you're going to have a judge evaluate these decisions under. And that is a heightened burden. And we recognize every day that both parents, when they come into our court under a original divorce, both of them come in on equal footing. They are both, they're the mother and they're the father of these children. They're the parents of these children, and they come in under equal footing when they set foot into that courtroom. There doesn't need to be a rebuttable presumption as to that because they are equal. It's up to them to present the facts and evidence that would comport with HB 314 to determine what is going to be in the best interest of the children. Not what the parent wants, but what's in the best interest of the children. Because in my other concern with doing written findings, and I recognize a parent always wonders, why did the result happen? But if it's a judge, if you have to write into an order why you ruled a certain way against a parent, and it's in a court order, and a child may happen to see that court order that would be negative about a parent, why would we expose the children to that? It's also a public record. Whereas if we write an order that states joint custody, and here is what we think is in the best interest of the children, by establishing the joint physical custody, we establish a different custodial schedule, whatever it may be, in proportion with the statute, HB 314, or the current statute that we have in place. Then we can protect the children and we protect the parents because we recognize that children are what matter in this regard.
Okay, Judge,
Sorry.
thank you. No, ma'am.
Sorry.
No, you were asking a question. I was giving you a second to try
Okay,
to
sorry.
respond. But I
Thank
do
you.
appreciate it. Thank you, ma'am. Mr. Malloy?
Dear Mr. Chairman, committee members, thank you for the opportunity to offer comments regarding my support for HB 365 or House Bill 314 with amendments. My name is Ray Malloy, and I've been a resident of Jefferson County, Alabama for 41 years. I live about 2 miles down the road from Matthews Manor near Springville. I'm here today to offer my public comment to the fact that I have not been able to see I'm here today to offer my public comment to the fact that I have not been able to see my son, John Noah Malloy, since he was 6, and that was 14 years ago. Because of this, I have intimate experiences regarding parental alienation and how many are affected by current custody arrangements and non-conflict divorce cases. Because of the failed current winner-take-all arrangements, I support HB 365 or 314 with amendments. This tale begins in 2014 when my spouse and I separated and the final divorce was granted. 2 judges, and 2 years later, we had an agreement. And when 2 years later, I had to file a rule not si for repetitive visitation interference. After tens of thousands of dollars later in attorney's fees, we had another trial, another settlement. Only after she was cross-examined did she want to have another settlement. She appealed it. It came back that she was denied due process because she was not offered the ability to have oral testimony.
So they awarded her appeal. So we had another trial. We had another settlement. We brought in a child custody, a child psychologist to reunite my child and me, and that failed miserably. We've had no contact since. That was 11 years ago. The damage had been done, sadly. I'm a 63-year-old grieving parent and resigned, and I'll never see my son again. The interfering parent spent well over $100,000 in legal fees. I went broke, and at some point I let my vehicle be repossessed in 2009 in order to fund the legal expenses to see my son. I share this because there are some folks who have so much wealth, they don't have mind picking up the legal expenses in case they're found guilty of interference with a court decree or some of the things we've said in these bills. I think the current system is broken, and our children need this bill to be protected. My son, John Noel Malloy, has missed 15 birthday celebrations, 15 Christmases, 15 Father's Days. This is my strong opinion, a form of emotional and mental abuse committed to my son, Noah. We need the wisdom of you all legislators to stop this abuse. These special days will never return.
Mr. Malloy, thank you so very much for sharing with us. We sincerely appreciate it.
One last
sentence. Dr. Smith, thank you, sir.
Thank you again. An important point that I want to make is that I am speaking in opposition to SB 365. And I want to note that on 2 occasions, panels of child development and child psychology experts from across the nation met to discuss joint custody. Neither time were they able to come to consensus on recommending a rebuttable presumption of joint custody, and all agreed that no one standard fits all families, and that factors that should lead to exceptions to joint custody include risk to the child of abuse or neglect, too great a distance between parents' homes, threat of abduction by a parent, and unreasonable or excessive gatekeeping, also called alienating behaviors. So I just want to emphasize that the science does not recommend a rebuttable presumption and a 50-50 time split in all cases. Thank you.
Thank you, ma'am. Colonel Edismore, please pronounce your name, because I have all the confidence in the world I did not do it right.
John is fine.
Sir?
John is fine.
Okay, sir. That's easy. Thank you.
John Eidsmo. I'm from Pike Road, and I came here 31 years ago with the Air Force. I'm a retired Air Force judge, advocate, or lawyer. I also pastor a couple of country churches. So I see this issue from many standpoints. I'm going to make my points very quickly, and I have a handout for everybody here. But number 1, children do better with input from both parents. Number 2, as I found as a juvenile court referee, parents are much more willing to pay their child support if they have input with their child. But the third concerns this issue of a rebuttable presumption. We see that term repeatedly in law, and I emphasize it is rebuttable, and the Bill 365 gives 18 reasons the judge can use in order to rebut that presumption, the last of which is any other relevant factor. And I think that gives broad discretion. I see nothing in this bill that talks about clear and convincing evidence. I'll define that if you wish me to. But I'll just say this, that I've been a senior staff attorney at the Alabama Supreme Court. I know that judges like discretion, but it is your responsibility as legislators to make the laws, and it is their responsibility to implement them. And sure, give them discretion. I think 365 gives them great discretion. But basically what this bill does, as I see it, is it establishes joint custody as the default position, which can be changed. Currently, the default position is custody with one parent, usually the mother. Thank you, sir.
Yes, sir. Thank you, Colonel. How about that? Judge Johnson?
Mr. Chairman, members of the committee, thank you for the opportunity to come up. I'm here as an opponent of 365, and I want to make it very clear that the substantive differences between these two bills is the change in definition and the change from a rebuttable presumption. That is the fundamental distinction between these bills, and that would be a fundamental departure from Alabama law. There have been a number of things discussed up here today, and I want to address a few of them. The reason we're concerned about the omission of an evidentiary standard is because there's no evidentiary standard set forth in the proposed definition. It states, this rebuttable presumption may be overcome only by evidence, comma, set forth in written findings of fact. Ordinarily, when there's a rebuttable presumption, there's a requirement of either being the preponderance of the evidence, meaning it's 50-50, or clear and convincing evidence. And so my concern as a judge is eventually, should this be adopted, the appellate courts are going to have to come in and make an interpretation of what evidentiary standard needs to be applied to this. And because it is creating a rebuttable presumption, ordinarily it requires clear and convincing evidence, which clear and convincing evidence is the highest evidentiary standard in the civil context. And so we know the difference between the civil and the criminal. The other thing that I want to address is in creating a rebuttable presumption, you're creating all parties the same when they come before the court, which is not always the case. We recently had a case in Lowndes County where the mother wanted to remove the children and move them to another area away from their home, their school, their church. The father was given primary physical custody pendent light. It resulted in a settlement where both parties were awarded joint physical custody. The mother remained in the community. They're both enjoying equal time with their children. Both girls will be able to grow up with their parents because of the ability to give one party primary physical custody during the course pendent light. All circuits around the state of Alabama are not equal in the way that they're utilizing their pendent light orders. And so this standard would apply from the time that the case is filed. There may be months in between the time that a case is filed and the time the matter comes before the court for a final hearing. And to create all of those cases and treat them all the same when you're dealing with high conflict parties, in most instances in a contested divorce, is extremely concerning to most of the judges in the state of Alabama.
Judge, thank you. Appreciate it. Kelly McTeer.
Good afternoon. My name is Kelly McTeer, and for the past 15 years, I've represented victims of domestic violence in a wide variety of family law cases. For almost 10 of those years, I've done so as a member of the faculty at Jones Law School, where I also have taught family law. I'm here today in my capacity as Vice President of the Alabama Coalition Against Domestic Violence to speak against the proposed House Bill 365. This bill represents a radical departure from existing Alabama law regarding children and will disproportionately negatively impact children at risk of abuse and neglect. While it purports to not limit the family violence and child abuse protections of Alabama law, as a practical consideration, it most certainly will. This bill's creation of a default presumption of equal parenting time and requirement of written findings regarding its successful rebuttal based on a set list of set considerations will not only limit a court's ability to fashion customized solutions for individual families, it also creates an insurmountable hurdle for most victims of family violence to overcome. It's a lot to say in 2 minutes. One simple truth is common among those abused by a loved one: they hoped. They hoped that their loved one would stop. They hoped that they would have a safe and secure home. They didn't live their lives constantly preparing to document the next attack. That means that as a general rule, victims of abuse are not in possession of the kind of court-admissible evidence that would effectively rebut a presumption of this type with legal certainty. Absent wearing a body cam 24/7 or being physically injured so severely that medical intervention was necessary, I don't know who would. Additionally, the existing presumption against granting custody to a parent who has been violent or abusive to family requires no specific written findings when it has been overcome. This new competing presumption would render that protection even less meaningful, effectively only coming into play once a judge has decided the legal grounds to deviate from the default joint physical custody standard have already been met. Few victims are in a position to do that, no matter how good their lawyers are. Even the simple existence of such a presumption will be used by abusers to threaten and scare their victims into staying in dangerous relationships to better protect their children. The provisions of this bill will place children who are already at risk in even greater danger and tie the court's hands to protect it.
Ms. McTeer, thank you. We appreciate you very much. Ms. Mitchell?
Good afternoon. My name is Kiana Mitchell, and I'm with the Alabama Coalition Against Domestic Violence. I want to share the story of a grieving mother with you all. She was unable to be here today, but she wants you all to understand the impact that the legislation of this sort can have on victims of domestic violence. On August 6, 2021, Kayla's ex-husband, Brian Beaning, shot and murdered her only son, Tate Beaning, before killing himself as well. Brian had a history of mental illness, PTSD, traumatic brain injury, bipolar disorder, narcissism, physical, emotional, and verbal abuse. They divorced in April of 2016 with an agreed-upon graduated custody schedule with several limitations in place. Per divorce papers, Brian was supposed to continue mental health treatment, no drinking or drug use while Tate was in his custody, and pay child support. Over the last year, Brian had ended a relationship and began spiraling mentally, sending Kayla more and more threatening and distressing text messages to include threatening to kill her. He had not paid child support in 2 years and had discontinued medical treatment. Her lawyer filed for an emergency hearing on July 9th to amend custody to supervised or no visitation until Brian sought treatment. The hearing was not set until August 9th, 1 month later. After finding out about the hearing, Brian went to a retail store on August 4th, purchased a firearm, and used it to murder Tate, Kayla's son, the night before or morning that he was scheduled to pick her up. Kayla called for a welfare check due to not being able to reach Tate or Brian. The deputy refused the welfare check, told her to go to the door, which she found unlocked, and then allowed her to go into the house and find her deceased son with gunshot wounds to his head. The current custody laws and justice system failed to protect Tate, and House Bill 365, if passed, would make it even more difficult for women and children in abusive situations to get out. This bill favors the rights of parents and does not make the safety of our children top priority. The presumption to start physical custody at 50-50 will further trap women in abusive marriages due to safety concerns and fear of their children being left alone with an abuser. Alabama needs to fight to ensure the health and safety of our children above all else. Abusive threats toward a parent should be seen as a threat to the child as well. The burden of proof should not be on the healthy parent. We urge you to listen to the voices of survivors across this state and vote against this bill. Thank you.
Yes, ma'am, thank you. And that concludes the individuals who have asked to speak. Now, as to the committee, if any of you have a question for any of those individuals that spoke, tell me who it is and we will bring them back up. Yes, sir, Mr. Wadsworth.
I do have a question for the district judge, and I forgot your first name.
Judge Johnson.
Judge, in HB 365, on page 2, it says provided the goal of something joint custody is the best interest of the child. Can only be overcome by that. If it's put in there, can only overcome by the fathers today, does that change anything?
I don't think it changes my perspective because I think you're still starting out, as Judge Durward and I both pointed out, creating all parents the same and putting their interest over the interest of the child. As the other two young ladies spoke about, I mean, our primary concern has to be with the best interest of the child and not putting what the parents want over that. And so whether it's a preponderance of the evidence or clear and convincing evidence, I certainly have a reservation about clear and convincing evidence because it requires the court to make those finding of facts. It makes it even more difficult to deviate when joint custody may not be in the best interest of the child. And so that's my concern, but when there's an omission of not including an evidentiary standard, I think that's extremely problematic. Preponderance simply means that it'd be like if you looked at it 50-50, if you had 51% and you barely tipped the scales one way or the other, that would be a preponderance. Clear and convincing would be akin to reasonable doubt in the criminal context.
Thank you, sir. Mr. Partner. To whom? Mr. McCoy?
Mr. McCoy?
I believe it's Malloy, I believe.
Sorry.
That's okay.
I apologize. I wanted to thank you for sharing your personal story, and I know that wasn't easy for you. And I did want to ask you a question, though, as you opened, and I would assume this question, I would pose it to everybody with the organization that you work with. Is 314 better than what we have now? I seem to get that from each of you as you spoke, is that I know you want 365 and you said 314 with amendments. I'm assuming you like 314 better than the current state of law.
As Representative Coleman originally brought up, she brought up in the context of, is this hearing going to be the two at the same time? That's why we're going to just put the two comments together and then we ask the questions afterwards. I was originally for 314 with amendments. Now I'm with HB 365. I'm for one or the other.
Okay, but I mean, my question is 314 better than what we have now?
If you were to ask me, I'm not a legal person. I'm not in the legal profession.
Okay.
So that would be unfair to ask that question because I could short sell one way or the other.
Okay.
But it's my opinion that it is. I'm going to withhold.
Okay. Thank you,
probably
sir.
so. Yeah, thank
Well,
you.
that was my question, so I appreciate your
I
time.
will say this, I've spent more time in front of this committee than I've seen my son in 16 years. Thank you.
I'm sorry to hear that. Thank you.
Ms. Coleman?
Thank you. I want to make a comment and then ask a question, if that's decent and in order.
ma'am.
Of course, also feel for the gentleman's pain, and also to our colleague who is the sponsor of 365. I met him, I keep saying 20 years ago, but however many years ago it was when he first started walking around the halls of the legislature and talking about this particular issue. And at that time, he knows, and I will share with you all, I was a young mother who was going through my own challenges. But even in a two-parent home, it is not often that parents spend 50% of the time together with the children. When I was serving in the Alabama legislature, and I'm here 3 days a week when I was married to my children's father, he was the primary custodian because I was here. But then when he was traveling with his work, I was the primary custodian because he had to travel oftentimes 2 and 3 weeks at a time. So to then now to try to say in a divorce situation where even in the two-parent home you don't spend oftentimes 50% or the equal amount of time, I couldn't fathom it then, and I still can't fathom it now. And now that I practice in this particular area, if we're talking about joint physical custody, which in some situations, especially with smaller kids, you're talking about 1 week on, 1 week off. That happens oftentimes. Am I correct for my judges? All right, so that happens. Not to talk too much about particular cases, but I have heard of situations where you've got a 1 week on, 1 week off, and then the 1 week on, that particular parent has to work. So instead of the children being with a loving parent, they're at the babysitter. So I just want us to think about those types of examples as we are getting ready to vote on these two bills. So I actually do have a question for my judges now, actually, as they have heard these cases. Because when we're talking about that equal time with the children, how often do you actually hear cases where both parents spend equal amount of time with the children?
Either one of you.
I'll go first. I think what you have to look at is each family is different, and the reality of each family is different. So you do have when I was growing up, what we thought of as traditional home is the man worked outside the home and the woman stayed home. I think we've seen a transfer or evolving standard as society has evolved, where you do have two parents who work outside the home. And so parents, when a family unit, they work together. So say one's a nurse and works night shift, so husband's at home that night to take care of the children, then mom's at home during the day. Well, the problem is when they get divorced, how is that reality going to be? And so as a judge and as a practicing lawyer, you tried to craft a solution, which is the nice thing about HB 314, is it gives parenting plans, and it requires each parent to present a parenting plan that they have created, that they have come up with to say, this is what I think as a parent is in the best interest of my child. And we may have competing parenting plans. That helps the court make a decision if they can't make the decision as to what's going to be best for the child. And I hope that answered your question. Because every family is so different, and that's why a judge needs the flexibility to be able to address the needs of each of those children and their families when they come in front of us.
Thank you for that. And I did forget to mention one detail as I was talking about that particular scenario. The parents lived in 2 different counties. They had kids going back and forth from county to county.
Judge Johnson, do you have anything to add?
I just want to point out that, and I think Mary Elizabeth did a good job of this. We developed a model parenting plan website for judges and for litigants or pro se litigants, attorneys or the pro se litigants, to be able to utilize, because every case is not the same, and we can't treat every case the same. That's the problem when you create a rebuttable presumption. We're trying to say everybody across the state in every case is the same, but it's not. And when we're looking at parenting plans, you know, parenting time, it may be different based on their work schedule. Let's say you've got a father that works offshore and he's only here for 2 weeks out of the month. Well, that doesn't mean that we're going to have the same schedule that I'm going to have that we have parents that live right up street from one another. And so we developed a model parenting plan website that has all of these different types of visitation schedules that the court can utilize in making a determination for what's best for the child. Because our ultimate goal in the cases that I've awarded joint custody, I've awarded primary physical custody to a father or primary physical custody to a mother, is what's best for that child and what's least disruptive. Because we know that there is nothing more disruptive that that child's going to go through than the divorce of their parents in most of their circumstances. And my job as a judge is to do everything I can to minimize the trauma on that child and ensure that that child's life is disrupted as the least amount as possible, and whatever we can do to facilitate that, to ensure that both parties have adequate time to be able to visit with the child. That's my goal as a judge.
Hang on, Mr. Chestnut, I'll get you, but go ahead, Mr. Wadsworth.
In both HB 314 and HB 365, and I'm directing this to both judges, alienation of a child from another parent is not listed in either one of the bills that I see, or I may be missing something. Is that, I'm assuming that's a factor that both of y'all use in handling this, and does it need to be included in both bills as a factor?
It's certainly a factor I consider. You know, whether we want to specify it in these bills, I think it would probably be a good thing to include. If you're, you know, should this committee vote in favor of 365, I think 314 is the better bill. But the thing in 314 is it doesn't create a rebuttable presumption, but it still gives the court factors to consider if the court doesn't award joint custody. And I think the alienation of you know, the child by one party or the other, or the alienation of another party through the child, is certainly a fact the court needs to consider. I have certainly considered that in the past when I've handled cases when you had high conflict parties, because oftentimes the child gets used as a pawn between the two parties.
Does both bills need to have that simply set out as a factor that the court would consider?
If you want to enumerate it as a factor, I think that would probably be helpful. It's a factor I think courts are considering. And so if there's evidence that comes in that there's been an alienation effort by one party to alienate the other party from the love and affection of the child, every judge I know is going to consider that as a factor, whether it's enumerated in statute or not.
Judge Durward, do you have anything to add to that, ma'am?
I think, just briefly, I think it is covered in a way of one of the factors we are to consider. It's on page 7 of 314, is the ability of parents to encourage the sharing of love, affection, and contact between the child and the other parent. And I think that directly goes on point with what we're supposed to look at when awarding joint custody, which is the parent's ability to get along with one another and adapt and work together for the benefit of the children. So I think it is included, and it's included also, I believe, in the factors we're supposed to look at with regard to the relationship between the parent and the child and their knowledge and familiarity, and the effect of the child of disrupting or continuing existing custodial status. So I think it's included in there in allowing us to hear evidence as to a parent's involvement or actively trying to impede a parent's relationship with their child.
Does that need to be included as a spelled-out factor in both bills?
It probably wouldn't hurt to have it as a factor. You would want to be careful on the wording, because you are going into what is more considered as what a psychologist would have to come in to testify as to what would be parent alienation, as it would apply in what we would have to look at. So it would go into maybe having to have a counselor come in or to talk about that, to give us the ability as a judge to make that finding. Yes, sir.
Mr. Pettis, do you have a question? I don't know who it's for. Judge Durward, you are still up.
I've talked to appeals court, and one of the biggest problems they have on child custody is on appeals that the judge don't tell why they ruled the way they did. I know you said you don't want to put it in the order why you ruled the way you did, but what are you not keeping our appeals court from overturning you because they have no idea what you were thinking?
No, Your Honor. No, Your Honor. See, I go back at default. Yes.
Hey.
There we go. It's my old training here. No.
She was thinking about me, Mr.
I
Pettis, so don't worry.
Any of my faults as a judge, I'm going to go back to Judge Hill. He's the one who raised me up. No, sir. What we look at and what we have to evaluate is the evidence that's brought in front of us, and that's through testimony. That's through evidence that we're allowed to consider. And so the record that is presented to the appellate court is presumed that we had information in front of us such that we can make that decision. And so when I used to do appeals, you would go through that record to find all of those facts that were brought forward at the trial that were brought before the judge, so to say this is why the judge either made this decision or this is why the judge is wrong in that decision. So that falls back onto what the attorneys, if they're representing the parties, or the parties, if they're self-represented, brought to the judge. So, because we're not allowed to go out and find evidence, we can only rule on what's brought in front of us. So that's why we have the ore tennis rule, because we can see the parties when they're in front of us. So when they say something, I can see their face to see, are they being credible with me? Or are they laughing while they say, oh, whatever? Or the reaction. And that is why we have the discretion, and that's why the appellate court allows the discretion when they're reviewing our decision. So it's not that we're trying to avoid the court knowing how we thought, but the evidence is going to have to be in there to back us up when it goes on appeal, and it should be there. If it's not, that's when we get reversed.
No, Mr. Chestnut?
Me still, or do I get to sit down?
I just want to ask a question for both of the judges, all of the judges here. What's the practical aspect of when a father actually says to the court, I want to be involved in my child's life? What's the practical aspect of whether or not that father will get an opportunity to spend time with his child?
I think that's the most wonderful statement any parent can make when they come into the courtroom and say, I want to be involved. And then it's up to either the parents through a settlement or through their testimony to help a judge craft how that's going to look. How are you going to be involved? How are you? Say you were the traveling parent and you worked out of town, because that's how it worked in the marriage. Well, how are you going to adapt your circumstances so that you can be involved as you want to be involved? And so that's why, as a judge, we need the evidence brought before us so we can make a learned and wise and just decision. So we, as a judge, we all want parents to be involved. That's why it's so important that when they come in, they're treated equally when they come in, and both have a fair and just and equal hearing so that we can hear all the evidence for how they want us to rule in their case, because obviously they hadn't gotten along, otherwise they would have settled their case. So how do we make that equal? So yes, we would want to hear that.
And my follow-up question is, because I think there is a presumption among many in this committee that judges just simply sit up and say, we're going to give the women all the rights in this case.
Absolutely not.
Okay.
That is not, it was not my experience as a practicing a lawyer for 25 years. If I, as a lawyer, came into court, and I represented a lot of men who got custody of their children, because we came into court and presented the evidence as to why, and why that was going to be what's in the best interest of the children, if they were going to be the primary physical or if it was going to be sole custody, whatever it was going to be. So no, I don't think that is the case. Now, maybe 30 years ago, that was when we had the tender years doctrine, and you know that was the presumption. But society has evolved. Your judges have evolved. You have judges with different life experiences. And so, no, as a man, they get treated just as equally when they come into court because they are a parent. And that's what's important, is who's going to be the best parent if we have to do a primary custodial arrangement with a parent, and who's that going to be? And you look at everything.
Judge Johnson, do you have anything to add to that?
I'd just like to point out this, and to get an opportunity to answer Representative Chestnut, says he's my neighbor in Dallas County. You know, we deal with this a lot of times in the context of child support cases where you have unmarried parents, and the father wants to come in and be a part of his life where he may not have even been aware that he was the father of the child. And I have a standard colloquy that I deal with the parties, whether it's in a child support or a domestic relations action or a custody action where the parties are unmarried and they're coming in and trying to establish custody, is whatever happened between the two parties is water under the bridge. It has to be about what's best for that child moving forward, and that what's best for that child normally is that both parents are involved in that child's life. and both parents have an opportunity to provide love and support with that child. And so most judges that I know want to see both parents involved and engaged in that child's life. And I would like to point this out because Representative Pascal, you brought up something about the judges around the state and that there are some judges, and I hope I don't know the judge that you quoted that said they never award it, but I do want to remind you of this. Judges are elected officials. You have the ultimate recall power. If there's a judge anywhere in the state of Alabama that is not following Alabama law, they are accountable to the people in their district or the circuit they're in. So there is a recourse out there if there are judges that are significantly deviating from Alabama law and not considering the policy of the state of Alabama, which is set forth in statute, that favors joint custody. But I don't think that it should be the policy of the state that we say that joint custody is a circumstance in every situation and create a very high burden for a court to overcome when it's not merited.
Mr. Simpson.
Yes. Now that we've had a couple of judges that have spoken on this bill specifically, I'm going to make a request that I don't normally get to make. Earlier this session, Representative Ball had HB 120 that was discussing alienation of parents in this. And I think some of the language that he had is some of the stuff that you guys have discussed. We're not voting on this bill today. Is there any chance, when I'm looking at some legal minds in the front row here, that you guys can take a look at HB 120 and see if you can throw an alienation clause into this to add it as an example into 314 or 365, and we can have some of the language from Representative Ball from that you guys that know the law can put it through there?
If they do and an amendment is offered, we will certainly take it up. There's no question that's accurate, no doubt about it. And Mr. Robbins, did you have a question?
I did, and I guess this is to the judges as well. The very last speaker, I really appreciated your story, and what she talked about was the very end was in some ways a shifting of burden. And I know we've talked about clear and convincing evidence, preponderance of evidence, but could you explain to the committee in some ways under 365 how that would shift the burden and who would have to, that if we pass that, it would shift the burden that you would have to prove that joint custody was not, and kind of talk about the shifting of burdens and how it operates now, compare and explain that to the committee.
I'll do that. I feel like one of the litigants in my courtroom. You keep being put on the hot seat. I got a little taste of it last week when we were here, and Judge Hill said, well, we didn't get to y'all. I said, well, I know how folks feel when I've had a 2-hour hearing, and I said, I'm sorry. I'm continuing your case. Come back and see me in a month. But Representative Robbins, I think that the important distinction here is this presumption disincentivizes settlement. If I know I've got joint custody and I'm representing one of the parties going in, then why is my incentive to try to resolve that case? I'll put it in the judge's hands every time then. Whether you're high conflict and you can't get along with anybody and you're fussing and arguing all the time, I think it's going to create a situation where you increase the burden on the court system in addition to the burden on all the other systems that are out there that are preventing family violence, because you're trying to create a situation where you're treating all these situations similarly. And so I think that that's one of the problems that we have when we deal with creating rebuttable presumptions out there, is you are basically trying to make somebody prove themselves. If you were in the criminal context, you look at this like a presumption of innocence, where you're trying to prove that you're not guilty, as opposed to maintain that presumption of innocence. Judge Durward put it very well. You come into court on a level playing field. And so...
Wait a minute, Mr. Sir, if you're going to speak, you're going to leave. Do you understand me? We are not going to, if you're not on this committee, this is their time to talk. Next week, you will be able to get up and answer every question. So let's not interrupt again.
But you come into court on a level playing field. And I can speak for my court. I can't speak for any other judge. But when you walk into my courtroom in Lowndes County, I'm going to treat everybody with courtesy and respect, and I'm going to give everybody their appropriate measure of respect. I'm going to give both parties an opportunity to present their evidence, and then we're going to make a determination about what's in the best interest of the child involved in a custody determination. Not what's best for one parent or what's best for the other parent. And I think that's the concern that the judges that I've discussed this bill with, is that we're placing the concerns of the parents over the concern of the child. And I think that's where the rub is in between these two bills. They both incorporate most of the same provisions. There are some outstanding provisions that are really, really good changes to Alabama law, but this is one fundamental departure I think is very disconcerting.
All right, ladies and gentlemen, are there any more questions for any of our individuals that gave their time to come speak to us? Yes, sir.
I have one more question. I'm sorry. Dr. Kertner-Smith, It's in your footnotes about the 2 panels.
Yes.
And could you kind of just maybe elaborate on that just a little bit? It's not a formal question. Just kind of elaborate what those panels were, what they determined, and why, in your opinion, they never could come to an agreement on this rebuttable presumption, and just what was determined from those panels.
One panel met in 2014, and I actually have the research studies or the published articles about that panel, and then another panel met in 2017. The 2014 panel was a panel of 37 child psychologists, child developmental specialists across the nation that met together to discuss joint physical custody. The other panel was a panel of 12 child psychologists that met to discuss joint physical custody. And there was some overlap in who was on each panel, okay? But the bottom line is everybody agrees that it's best for children to have both parents involved in a child's life. And it's quite correct by citing the ACEs study that children fare better when both parents are involved. But there's a big but there, and the big but is the history of abuse, the history of drug use or substance abuse, domestic violence. Those things really need to be considered in simultaneously when considering joint physical custody and making a determination about what's in the best interest of the child. So back to the panels, they all agree that, and I've actually published research myself that finds that children fare better when they have continued relationships with their fathers. But time does not necessarily mean quantity. Quality and quantity are two different things. And the second thing is that they stop short in recommending a rebuttable presumption of joint physical custody and a 50-50 time split. So,
Okay, thank you, ma'am.
does that help? Does that answer your question?
All right, ladies and gentlemen, we're going to close this. Now, let me say this. The reason we don't vote on this today is because if there's something else that someone wants to present to the members of this committee, I want you to. You can get it to Brandy, and we will get it distributed and disseminated. I appreciate everyone coming. I really do. This is we take up a lot of issues in this committee, and a lot of them are hard issues. I'm not sure we'll ever take up an issue that's more important than child custody and child visitation because of what it does and the ramifications it has for years and years to come. So for every one of you that came to spoke and every one of you that's interested, we sincerely appreciate your input and we sincerely appreciate your time. At this time, though, I'm going to give you all, if you would like to exit, or you are welcome to stay and hear Representative Treadaway and Representative Morris talk about their criminal bills. I don't care. I'm gonna hold Coleman till she gets back.
So Treadaway, Morris, don't forget to do Chambers.
I know, if I can, I will.